Have you found yourself as a personal representative in an estate sale? You likely have a lot of questions. Let's talk about that.
Welcome to another episode of Behind the Scenes.
On today's Behind the Scenes, we have the distinct privilege of talking to Jeremy Yates, attorney at law. Jeremy is an estate planning and probate attorney here in the Puget Sound area, in practice for over 13 years. He is a wealth of knowledge. Jeremy, thank you so much for taking the time to chat with us today. Really appreciate it.
What a pleasure, Aaron. Janus.
So Jeremy, why don't we just start with kind of a general discussion here. Tell us, what is an estate?
So an estate is a legal entity, and it's a taxable entity that is used to manage the affairs of deceased people in our lives. And so the legal entity is set up when the probate lawyer goes to court and opens the estate in the courtroom with a court order. And the tax-paying entity is set up when the personal representative of the estate contacts the IRS to obtain an EIN number from the IRS, indicating to the IRS that someone has died, the personal representative is appointed, and the estate will take care of filing the decedent's last tax return.
So Jeremy, can you define what probate is for us?
Yeah, sure, Aaron. Probate is what we call the legal process that we go through to administer the estates of deceased people. So a typical probate begins when the lawyer takes the will to the court and asks the judge to approve the will and say, hey, this will is valid and so on. The personal representative is appointed. Either that, or we go into court and we say, there's no will, Your Honor, person has died, they've left assets and debts, we'd like to administer this estate. And so in either case, a probate is initiated. Will or no will, it's still a probate. And then the probate is basically a process that starts and finishes and is defined by statutes that govern what the personal representative is supposed to do and how they're supposed to go about doing it. But to generalize, there's 3 stages to a probate. The first stage would be marshaling all of the assets. The personal representative has to go out and find all of the things that a deceased person owned, including bank accounts, investment accounts, retirement accounts, life insurance, homes, rental properties, raw land, cars, all kinds of assets. So the personal representative marshals the assets by finding them and taking control of them and securing them. All of that's kind of the first stage of the probate, marshaling the assets, securing the assets. Then the second stage would be figuring out who all the creditors of the deceased are. Who does the deceased owe money to? And so we get a complete picture of who the debts are. And we do a variety of things to do that, which kind of go beyond the scope of our discussion today, but we figure out who all the creditors of the estate are. And then the third step in the probate generally is we pay off the creditors and we distribute the net estate to the beneficiaries. And there's a lot to each one of those steps. A lot of work there for the personal representative mostly, a little bit of work for the lawyer, work for the real estate agent and so on. But in general, that's the probate process. And so the probate process ends when the personal representative is satisfied that they've done all the work, that everything is done. There's no more assets to collect. There's no more debts to pay or contest. And all of the deceased's property has been distributed to the right people. And at that point, there's a simple filing that we make in the court, or we set a court hearing in some cases to close the probate estate with closing filings in the court record.
Perfect. Thank you for that. So Jeremy, walk us through who the players are in an estate.
Sure, Aaron. There's a couple of layers of players. On the top, the topmost layer is the personal representative, sometimes called executor or executrix, administrator, administratrix. All of those terms have given way lately to the term personal representative, and that's the individual charged with administering the estate Normally that person's named in a will. Otherwise, it's generally a family member or friend of the deceased. The probate lawyer usually represents the personal representative and helps them with the legal needs of the estate. And the courts are a player, therefore, because the probate lawyer opens the estate in the courts. So sometimes the courts are involved in a probate, sometimes they're not. The beneficiaries of the probate estate are also sort of top-level individuals involved in the estate, and the creditors of the deceased are top-level individuals. So the PR has to work with the creditors, work with the beneficiaries, work within the court system and the laws. The lawyer advises the PR. And then on the second level are all of the people and institutions that the PR has to work with. So for example, the PR is going to have to work with real estate agents, taxing authorities, real estate recorders' offices, government agencies of various types depending on the estate, other kinds of professionals like accountants and people who are going to fix up a house, people who help the administrator with the particular assets of the deceased.
Okay, so it sounds like if there is a will, there's a personal representative named in that will. If there is nobody named or there was not a will before the person passed away, who gets to be the personal representative? How does that process go?
Sure. Well, you can imagine that these things happen in all kinds of ways. The timing is, the timing of death is rarely well planned. And so you might name an executor in your will, and then that person predeceases you and you don't update your will. And so even when there's a will, you can end up without a named executor. And in that situation, as well as when there's no will, the courts are going to appoint a logical person to be the administrator. And so that person is usually somebody who falls within a priority list that we have in our Washington statutes. So top priority to be named administrator would be the spouse of a decedent. Second priority would be a child of the decedent, and it goes on logically like that through family members. And ultimately, however, if nobody steps forward to administer the estate as personal representative, any person can do it. And so, for example, sometimes a person dies, all of their loved ones are already dead, or they were generally alone in life, and there's nobody to administer the estate. Sometimes the court appoints lawyers to administer the estate because the assets have to be administered, the debts have to be administered. And so sometimes I do that. Sometimes I'm appointed as the personal representative. So the real lesson is do a will so that you can name your personal representative and keep your will updated as things change through your life. And the people who you might have trusted once fall away, you lose contact with them, they die, they become untrustworthy for a variety of reasons. You want to be the person to name the personal representative of your estate.
So Jeremy, whether there is a will or there isn't a will, can somebody go this alone, or do they need to hire an attorney to help them through this process?
Sure. People do go it alone. It is possible. I have found though that, they make mistakes. And so it's been done. People continue to try to do it, but oftentimes I'll be hired by somebody who tried to go it alone for a few months, and the legal requirements and the statutory duties of being personal representative eventually can overwhelm people, and they end up with too many questions that it's hard to find answers to on the internet or elsewhere. So let's say you have an estate that is worth $500,000. If it goes well and if it's straightforward, hiring a probate lawyer is really not that expensive. Frequently those estates, I start and finish them with a personal representative for between $3,000 and $5,000. And that's if it goes really well. So, and hiring a probate attorney from the start can help it go well from the start. So it's like a foreign language for people. When you start it, you've never learned any of these terms, you've never read the statutes, you don't know how to operate in the court system, and a lot of people try to figure it out, and run into roadblocks and so on. And so I think sincerely it is a good idea to hire a probate attorney. It can keep you from running into problems, and it's actually cheaper in the end a lot of times than trying to go it alone and making mistakes or going through trial and error processes.
Makes sense. Like everything in life, if you want it done right, it pays for itself to hire a professional to do it.
There are not a lot of things that I'm not willing to hire a professional for, Mr. Janus.
I know that to be true. So Jeremy, let's dive into some more specifics as it relates to the real estate part of this process. I guess the first question is that at what point does it make sense to bring in a realtor?
Good question, Aaron. I tend to ask my clients very close to the beginning of the probate to interview realtors if they haven't already selected one. I think it's good to bring in the realtor close to the beginning for a variety of reasons. There are a lot of, the house is the most complicated asset of most probate estates, because when a person dies, of course, they die and they leave their house as it was that day. So it's full of the person's stuff from life, and that stuff has to be gone through by the family. The personal representative has to go through and look for bills and evidence of assets and debts. Ultimately, the house has to be cleared of all of the deceased's personal effects. And then the PR and the real estate agent have to find skilled labor, skilled tradespeople to go in and fix up the house, maybe to do the carpet or make repairs in the home. And skilled tradespeople are in very, very high demand in the Puget Sound area right now. And so getting them scheduled to come make necessary repairs and upgrades to the house can be difficult. And they might be booking a couple of months out to do projects, especially if all of this happens in the summertime, spring and summer. So getting a real estate agent early means that the real estate agent's going to start hopefully advising about the repairs that need to be done, helping the personal representative schedule tradespeople to come in and do the necessary work on the real estate. Also find and schedule estate sale professionals who are going to stage and sell what assets that the family doesn't keep. And all of this has to happen in a certain order, and it all has to, you kind of want it to happen in a timely manner. And so the best real estate agents that I've worked with help the personal representative with marshaling all of the professionals that are needed to clean out the house, sell the deceased's personal items, and organize all of the carpet people, the repair, the plumbing, the electrical, the roofing, all that needs to be done to put the house in saleable condition.
So when selling a home in an estate, what are a few things that shouldn't be overlooked?
Well, I think the first thing is get the real estate agent's opinion about how much the estate should invest in the house. Not all houses are worth investing in my experience, and it tends to be a ground level analysis where careful advice and thought from the real estate agent about the local market, the local neighborhood, and whether it's wise to sink money into a particular house. That's very valuable. And the PR should really have that advice as early as possible, because it drives all of the stuff I just mentioned in terms of organizing contractors and subcontractors and so on to prepare the house for sale. I usually look at the deed history, the real estate title history of a house when I open a probate. I try to look at that early in the process because there might be title issues that need to be squared away. For example, in a situation where a house was owned by two spouses and one spouse died, say 3 or 4 years ago, is that prior spouse cleared from the real estate title history so that that spouse's interest, the predeceased spouse's interest in the house, does not get in the way of the schedule to sell the house now that the second spouse has died. There might be lien holders in the title history that need to be dealt with. And so you try to figure out what issues you might run into from a title perspective when the house gets into the sale process, when it actually goes under contract and you're working with title insurance, escrow, and so on to get a house sold. It's nice if the title issues have been dealt with previously. A quirky title issue that sometimes arises and maybe is growing in frequency now is related to committed intimate relationships. And so that is a form of relationship that the law has given a name, committed intimate relationship. Really, it just means you're cohabitating with somebody, a life partner, but you haven't gotten married. And there are situations in which you might own a home individually, you take in a girlfriend or boyfriend, you start cohabitating, start sharing expenses on things, you live together for a number of years, and then somebody dies. It can be the case that the person who moved into the home, who's not named on title, who you had a committed intimate relationship with, actually acquires some kind of monetary interest in the home, or an equitable interest in the home, sometimes we say in the law. And sometimes that stuff needs to be dealt with one way or another.
Jeremy, I want to circle back because you were talking about, repairs and things that may need to be done to the home prior to sale to maximize the net proceeds. And I get this question sometimes, can an executor, can a personal representative use proceeds from the estate that hasn't been settled yet? Do they have access to capital there to make these improvements as part of that, as part of the estate?
Sure. If the estate does have liquid capital, it can be used to fix up the house and landscape and make repairs and even major upgrades if it makes sense. It just depends. Every estate is unique. And so some people die with $100 in the bank and 3 rental houses, right? And there is no cash
Right.
to fix houses. Some people die with, $1 million in investments and a small condominium. And so only a few $1,000s is needed to do a paint job and some recarpeting or something. So it's very, estate specific, depends on the financial position of the person who died. But it's a balancing act. And so if the estate has, $30,000 or $50,000 in liquid capital, how much of that do you sink into the house? The PR has to take the advice of their counsel, the advice of their real estate attorney, and have to find the balance so that they don't spend all the money repairing the house and find they don't have, liquidity to deal with a major estate issue that comes up before the house is sold. So it's just a careful analysis with the individual client for the real estate agent and lawyer.
So Jeremy, I know each of these situations is unique, but what's a typical time frame from the time maybe you get started until, specifically for the real estate, until you get to the point where you can list that home for sale?
Yeah, because of the number of things that have to happen in a certain order to sell a home in an estate, it's hard for me to imagine it happening. And I think it's hard to get it done in under 3 months because, again, you're talking about having the family be allowed time to go through the house and get sentimental items and clean up the house a little bit. And then maybe the estate sale rep comes in and sells what the family didn't take. And then the clean out person comes in, gets all the rest of the stuff out. And then the different subcontractors come in, the plumber, the electrician, the drywall person to repair the home and get it ready. Then maybe somebody lays new carpet and does the paint job. And so it's an enormous undertaking. And that's why, you know, it's rarely done in less than 3 months.
Right. So moment ago, you talked about title issues being a thing that you want to dig into early on. What are some other pitfalls in the process that people might not be aware of?
Other pitfalls are legal in nature, where unfortunately beneficiaries sometimes disagree about who should be able to take what from mom's house after she's passed. There are disagreements among beneficiaries sometimes about how much to invest in repairing or upgrading the house before sale. The personal representative has a lot of power and a lot of responsibility to deal with these things and settle them, and sometimes they have to use the courts to do that, so sometimes there's time involved there. And you know, not everybody, sometimes people die and there's still someone living in the house, like a boyfriend or girlfriend, and so or somebody who the deceased was trying to help out for whatever reason. And so, you know, every great while there's an eviction that's part of this, or some kind of you know, legal proceeding to settle up with whoever else is living in the house. But I have to say, you know, I don't want to scare everybody. The vast majority of estates of people who die leaving a home, it goes well, because most of the time there's not a lot of issues. You hear about the ones where everything goes wrong and it's a disaster and the courts are involved and so on, but most of the time it goes really well, because most of the time the deceased had a decent plan, or the family is reasonable with each other. They hire counsel early, they hire a real estate agent early, and they do a good job managing things. So the pitfalls are the pitfalls, but I do want to say most of the time it goes fine.
So Jeremy, we touched on earlier what makes this the most seamless process is by planning ahead of time, getting with an estate planning attorney and doing a will, etc. Should that not have been the situation with someone, what should people do to make the process the easiest?
Sure. Well, so the first thing to keep in mind is that it is never easy. By nature, when you die, you leave behind a host of assets and family members and creditors and stuff that you've accumulated through a lifetime. So the expectation that this is all going to be easy because I did A, B, and C is just unrealistic. The way that we make it easier, the way that we make it as smooth as we can, is by planning ahead and putting things in writing. And so the best thing to do is to visit your estate planning attorney, talk through a will with your attorney. Who should be the personal representative? Who do you want to give your assets to when you die? Do you have particularly important sentimental assets that need to be directed to one person or another to prevent, you know, battles between family members? Is there a troublesome child or beneficiary that you are concerned is going to make things difficult for the personal representative or their siblings or other beneficiaries? Is there a person in your family has an addiction or has special needs that need to be met, and therefore you should put a portion of your estate in trust for that person so that they're not managing it, somebody capable is managing it? Really share a lot of detail with your estate planning attorney about the reality of your family life and the people that you want to leave your money to and the people you don't want to leave your money to, or who you're worried about. And that way the lawyer can help you create a plan that takes into account the problems that might arise. And then talk to your family about your plan so that it's not a surprise to them when you die, and so that people aren't left wondering, why did mom do this? Why did dad write his will this way? As an attorney working in this area, it's never fun to have to explain the hard realities to people after mom and dad have died. It's a lot easier and better for everybody if mom and dad share that stuff while they're alive, because they can share it in the loving way that they would share it with their family, and deliver that, message personally.
Well, Jeremy, I really appreciate you taking the time to talk to us today about this. I guess first thing, if somebody wants some more information from you, how would they get a hold of you? Where would they find you? Besides looking below at the links to your information.
Well, I think it would be lovely if you put a link to my information below, Mr. Janus.
Okay.
Call me, email me. When it's a probate, I like to talk to the client relatively early, because usually people have a lot of questions and a lot of concern about the process, and I can demystify the probate process, what you have to go through for your loved one's estate. It's not the end of the world going through probate. It's manageable, it's doable. And I like to be able to talk people through the basics early on so that I can kind of depressurize the situation for them, de-stress it.
Well, that is outstanding. Well, this is great information. Thank you again, sir. Much appreciated. And
my pleasure. Thank you.
Thanks again. Thank you for joining us on another episode of Behind the Scenes. As always, we hope that you got a lot of value out of it. We would love to hear from you, so please drop us a line, and of course, follow us on social media. Thanks again, and until next time, take care.
House goals realized. Janus Group at Remax Integrity.
It's a tooth!